Welcome, everyone. This is Tansen Fairmont. Welcome and thank you for joining us on the October 10th, 2018 Brilliance and Commerce Trust webinar. We are in a period of world consciousness rising, and we just started the 10 days of Mother Divine in the Navaratri Indian tradition. We also are seeing the progressive and accelerating takedown of the Dark Age rulers of darkness, and everyone's been celebrating that progress, although most of us also wish it would go faster. and as you know, we have today the privilege of continuing a wonderful series on the International Natural Law Trust. This kind of trust is a part of the golden age. It's part of the multi-generation, multi-century, multi-millennia tradition of trusting others more than we trust the force, the power of force, or the armies and the courts and the police and the banks. We would rather trust each other to look over each other's assets. This has been a time-honored tradition. Brilliance and Commerce Project of La Vérité, which means the truth in French, has promoted and taught. We have today Randall Hillner, who will be speaking on these trusts and continuing the subject of the trust manual. Liberty Debt Elimination System is for United States debts, unsecured debts, the credit card debt, and student loans. We have affiliations and special offers with wealth building systems, credit repair, gold purchasing concierge, offshore asset protection, Monaco Management Group, wealth management, cryptocurrencies, and so on. So we have a lot of things. Most of it is conveyed either by the website or the newsletters, but these webinars also go into the trust. The time-honored tradition of the International Natural Law Trust is globally applicable, honored in all countries so far as we know. The principle of entrusting assets to people that we trust, to family members or friends, people that can be relied upon to oversee those assets properly, or in the case of where we choose ourselves to be the trustee and appoint other officers of the trust, is the flexibility that the House of Freedom branch of Brilliance and Commerce provides to our people, flexibility in who you want as trustee, yourself, a friend, or a professional trustee service that we are in the process of organizing. This flexibility, as well as the ironclad bulletproof strength of the trust, has made it an international celebration, 3 decades strong and counting, of no problems, continued success. We wish for anyone who does not already have one of these trusts to purchase it through the person who invited you if you have an affiliate. If you do not have an affiliate, there is a generic site, houseoffreedomtrust.com, house-of-freedom-trust.com. But like I said, the preference would be if you have someone who is an affiliate, please honor them and go through their link. There is also the opportunity for those of you who are not already affiliates to be affiliates with us. If you would like to help spread the freedom from excessive taxes, freedom from the banking debts and crimes that the International Banking Syndicate have been committing by providing the Liberty Debt Elimination System, we would call you an ambassador of freedom. Today being October 10th, 2018, we have our next trust webinar, November 7th, 2018. For those listening by telephone and those who do not have easy access to the internet or a computer or a smartphone, if you ever need assistance and you need a phone number, our Brilliance in Commerce new voicemail greeting is on. We used to have this robot voice, which wasn't very nice. We finally have a wonderful new uh, female voice created by our webmaster. So that number is 360-200-7521. We do prefer that you go online and use the help desk ticket system and put your questions in writing if you do have access to a computer. But if you don't, use the phone number. There is also the newsletter. We send 2 or 3 times a month. I mean, it's not any kind of special date or regular date that it's sent out, but it does give the announcements of these webinars as well as a lot of other things. And if you're not already a subscriber, please go to houseoffreedomtrust.com with dashes between each of those words. Click on more and then newsletter sign up. Actually, no, we don't have the more anymore. We just have newsletter sign up. It's been improved. So just look for newsletter sign up at the top of the page there. My name is Tansen Fairmont. I'm the founder, and I'm on the board of advisors of Monaco Management Group, our associate company. I've been a speaker on various radio shows and former offshore investment seminars, and I'm the author of Sovereignty Consciousness and a new book which is forthcoming, Cosmic Renaissance. So stay tuned for news about that. Randall Hillner is our featured speaker today, the head of our trust department and director of House of Freedom Trust, White Light Unlimited, trustee of One People's Public Trust, creator of International Natural Law Trusts, also Monaco Management Services, which is going to be providing trustee services. So these trusts are a best kept secret of the super rich. They've been used by the Rockefellers, the Rothschilds. They've been used by those who did not have humanity's best interests at heart, but the trust is not at fault. The trust is just a neutral instrument like a computer or like fire. Fire can be used to cook food or it can be used to burn. And same with these trusts. They're asset protection instruments. They're among the very best on the planet. They're very, very strong, bulletproof, but peaceful people who are the people we speak to, the part of our worldwide family, our network, are those who are creating peace, those who are using them for life-supporting, universally harmonious purposes, and have been enjoying protected status for decades. Generations, a few thousand of these people have been quietly successful in what others said is impossible. Yeah, impossible because some attorneys don't believe in them. That's why it's better usually not to talk to bar licensed attorneys about these. There is an international network of experts that we associate with. There are bibliographies of books we have published in our newsletter from time to time. Randall recommends various books, and he himself is providing this webinar series. So the education on how to administer these trusts comes from these sources. Okay, so at this time, I'm going to unmute Randall and open your video. And please, Randall, would you go ahead and illuminate us on what you have to share with us?
Yes, you mean you want me to shine some light on this subject?
Yes, can you speak a little louder, please?
Sure, I can get closer to the computer. Does that help?
Well, if anyone else has access to the chat and you have a comment on the volume that Randall is speaking at, please put in your comment. But Randall, please proceed.
Okay. Well, last month we talked about the trust manual. We started.
Okay, people are saying sounds good. So
all right.
Maybe it was just on my end. Please go ahead.
So we talked about the makeup of a trust, what it takes to start the creation of that indenture, and who are the people involved, what they need to uh, provide, etc. And this month, this afternoon, we're just going to finish up on the trust indenture, and then we'll take some more questions, of course. And the first thing you have to be aware of is the trustees need to use reasonable skill and prudence in their approach to what they do with the indenture, what they do with the trust and the activities of the trust, and how it best serves the beneficiaries and the whole process of keeping the assets safe. So I've just lost my script that I was going to run off of, but maybe you can bring it back. So, but the idea is that skill and prudence are just reasonable care and being able to step up and take care of the assets in the trust. You don't have to be a banker or a whiz or anything. You don't have to read all of the trust books that I've read during the last 20 something years or more. And you just need reasonable prudence. So we go from there, and then, whoops.
Yeah, hold on a sec. I'll get back
Okay.
to it.
No worries. I'm not going anywhere. I will just await your arrival.
Got to get to the right screen here. Okay. How's
All
that?
right. Very good. Now we're back. Now we're cooking with gas.
Okay.
All right. And then the second thing we want to consider is that the whole duty of the trustee is to ensure the privacy. And by that, I'm saying that the trustees are under a fiduciary responsibility to not share any of the activity of the trust and the activities of the trust except where they're in the public sector. So in other words, the trust can do business anywhere it wants to. It can provide investment opportunities through itself or through other people. And actually, when you go to the bank to open up an account, when you have the whole complete trust document, most of the banks now want to see the indenture, the whole, what that first primary part of the trust is. And so you have to remember when you go to the bank that they have different demands also than others. So businesses might be more readily accessible, and if they know, if they have a look and they see briefly what the indenture is. But the thing that's private is that you don't want to share the minutes with anybody without the trustee consent. In other words, you don't have to give the minutes to the banker. You don't have to give the minutes to anybody. In fact, if there's ever anything going on, you can say, well, I'm sorry, but this is private and you will have to get a subpoena in order to see this with a lawful, process against the trust. But that never had that happen, so it just goes on there. So the idea is that over time, every time there's an activity with the trust, you're going to write down what that activity was, and you're going to date it, and you're going to sign it, whether you're a trustee or you're the settler, and you put it in the record books with the rest of the trust. Now, if you ever have to take your trust document to the bank, I would suggest that you take the minutes out, or you put them in a special section and you clip them closed so that sticky fingers can't go through the minutes and find out what's going on with the trust. But sometimes you'll have to tell the bank, or maybe you're going to get a loan to get a house. Maybe you're going to the county to record a new piece of property that the trust has just purchased. So you're going to take that and you're going to start my video. Yes, sir. How's that? Hey, look at that. The guy's on a green screen. Okay. Start my video. All right, here we are. So we're back, and we are live from the island of Kauai, and we're going to maintain records. So we write it down and we put it in the record book, or put it in the trust minute section of your binder, and you're going to keep it there. And every year you're going to go through those minutes and you're going to kind of encapsulate what went on with the trust during the last year. If it's doing a lot of activity, then you want to have that come forward, be available. If you're just waiting on the RV exchange, then you probably won't do anything. In fact, a number of our clients are going to use it just for the exchange. So the important thing is that once you get your trust document, you're going to get a particular schedule, and you're going to record the individual currencies that you hold that are foreign currencies. And you're going to have to take those to a notary so that it's a date stamp on the notary, which means that the trust it's a sign that the trust actually owns the asset that you're putting forward into it. You don't have to do that for everything you put in the trust, but anything of significant value or potential value in the future, you want to have it notarized, and that way you have date stamp times. You don't need a time stamp necessarily, but a date stamp is always good to have. So there you go. You're maintaining records, you're ensuring the privacy, you're communicating with your the beneficiaries. You want to keep them. That's not something that the beneficiaries can demand, but it's something you want to do for the beneficiaries. Is if you're waiting for something to happen, it hasn't happened yet, you don't have to say anything to beneficiaries. But if let's say there's a significant business happening with the trust, and you want to dissipate the profit from the trust to the beneficiaries, then you would send out checks. You would notify each beneficiary that you're going to receive a check in the mail, etc. So that's what that would be all about. There it is. So we have the next slide, please. Okay, dealing with the trust property. The trustees are really unlimited in what they can do, as long as it's a legal process that they're involved with. Nothing illegal, can't do anything nefarious as a trustee, because that's how the trust will eventually get broken. And can you move this slide over a little bit? The second part, B. I got all the people in the way here.
This screen sharing doesn't allow it to be moved, but
Okay.
It says be approval by trustees for benefit of beneficiaries.
Okay, so that's good enough. So what you have to do is trustees must do things that will benefit the beneficiaries. Trustees can be paid. They can take a stipend. They can take a salary if they're doing a lot of work. In the beginning days, some of us just would have the beneficiaries take us to a restaurant once a year, and we'd have a business meeting. We'd talk about what happened the year before, what we wanted to do in the future, this next coming year, either immediate or long term. and then they would buy dinner for us. So it can go from there to literally being paid on a regular basis for doing the work that any really good trustee or manager would do for any kind of business. So the idea is to have some understanding of the business of the trust, take care of the beneficiaries, and take care of yourselves as well. Next. Okay, when, how often? Like I said, you can do it once a year, at least once a year, or you can do it on a regular basis. Usually, when you're doing a fair amount of activity, you and the other trustee, or if you're the sole trustee, then you would be writing down, jotting down what, like on a daily basis, what you're doing. And then if you have two trustees, then you'd want to be communicating with the other trustee. What you have to do is, if there's an activity that happens, then you would say, you write down, one trustee would write down the activity. They could scan it or send it as an attachment, email attachment to the other trustee. The other trustee signs it, and then you bring it back to home base, and each trustee would keep a copy of that activity. And the same with that once a year process. And that way you have both trustees have that whole trustee record book. They back each other up. Now, if you only have one trustee, then you have to be diligent in keeping. I'd suggest you keep another copy anyway, and keep one copy on your working desk and one copy in a safe place in case something happens or anything like that. So you have at least two copies floating around, and they're kept private, and that's how it works. It's like running your own life, except instead of yourself, you're taking care of the trust assets and the beneficiaries. Okay, next. Okay, the liabilities. A lot of people are kind of afraid of this, that if they become the trustee, they're going to be liable. And you're only liable if you have any malfeasance against the workings of the trust. In other words, you don't want to steal, you don't want to commingle funds, you don't want to do anything that jeopardizes the assets that are going to go into the trust and potentially then go to the beneficiaries. Beneficiaries being your children or your friends or an institution or anything like that. So it's like any fiduciary responsibility, you must take that responsibility seriously and have a good time, but also don't violate the trust contract. Okay. Next. Okay, now you have two things. If you have a bad trustee, the other trustees can say, okay, we need to correct this situation and either fire the trustee, or the settlor can appoint a protector. That protector's sole job is to hire and fire trustees if there is a malfeasance or is a wrongdoing on the part of the trustee. And then, but it's only for cause. So you can't just willy-nilly, if you don't like the trustee, but he's doing a good job, if he's doing the responsible job for the trust asset, then you can't go in and just say, we don't want you anymore. So be really careful and only look to see if there's a cause that the trustee needs to be replaced. Next. Okay, anything to run this business or run the trust affairs or to serve the beneficiaries is coming out of the assets or the trust. So anytime you have an abundance and you want to disperse it to the beneficiaries, you can do that. Just make a record of it. If there's insurance needed, if the trust buys a house and it needs to cover insurance, then it would do that. Also, caretakers, managers, a trustee fee. So it's all inclusive. It's like any business. You have to pay the people that make it all work. Looks like you got a roof that's beginning to collapse, so you're going to have to put a new roof on your castle. That would be a direct expense to the trust. Well, you might want to buy some swans for the little lake in front here. Okay, next slide, please. Okay, so now we're going to walk into the bank, and you have a trust that has a fair amount of experience with the work that it's been doing, and it has credit. Then you can go to the bank and you can say, we'd like to borrow. We have this project in mind, and we would like to borrow some money so that we can make this project happen. And then the trust would pay for all of the loan expenses, and it would be a direct payment from the trust back to the bank. And you, as trustee, may have to co-sign for that bank loan. It just depends on the bank. Again, if you have a relationship with a banker locally, then certainly work with the officer or the bank personnel that you know. And if you're waiting for the exchange to happen, then there's really not much you have to worry about, but you do have to pay attention to what's going on. Next. Yeah, this is again where the trustees will have to go to the county to record the new deed. Let's say you either purchase a house or an estate, or you're selling an estate. You would have to go to the county office and transfer the deed, receive the deed, and record it with the county, so the county knows who to tax, because the trust will have to pay any property tax, any insurance policy. And just because you have your house in the trust doesn't mean that you don't need insurance. You want to have proper insurance, proper maintenance. I was just reading this morning where a trust had a piece of property and somebody didn't take care of it, was responsible for it, and had an accident, and he tried to sue the trust, but the trust was able to step forward and say, no, you didn't have the proper insurance on it, so you can't really touch the asset. So you got to take care of whatever you take care of in your own personal life with your assets, you have to do with the trust as well. Now, I think we talked a month ago or so many meetings ago about not putting a car in a trust, not putting any kind of liability into the trust, especially if it has any kind of stable assets. If it has a house or it has a bank account, then you don't want to put something that can cause damage to another piece of property or to a person in the trust. If you have a valuable car or have your own jet airplane, then you'd put that into a separate trust and keep it away from the main asset. But my thought would be is always, if you have that much money in the trust as an asset, then you'd lease the car or you'd lease the plane, because then the leasing company is one that's going to have to be liable for any damage. But better to keep it away from the trust. Okay, next. Generation in minutes. Okay, who was present, what date, where was it, and then what activity did you take? What evidence of actions and decisions. That's the most prevalent thing that you have to consider when you're creating minutes. And then you make copies of those minutes. If you have both trustees there or you have the settlor there, then you would actually, the settlor has stepped out of the picture by this point in time, but the trustees would sign, and you'd make copies and you'd put it in your trust record book. And then you have a running tally. It's just like having a running tally in you have a retail business. You write everything that came in, everything that went out, action at the end of the day, etc. Okay, next.
Okay, everyone. Well, thank you, Randall. And unless you have some more comments, would you like to open it up to questions?
I would. That's how I always feed off of questions.
Yeah. So for those who called in by phone, press *9 if you want to raise your hand. And for those who are logged in by computer or smartphone, click on the raise hand button. And while we're waiting for that, Randall, I did have a question emailed to me. Let me go look for that. Yeah, so Pat writes, it would be more comfortable for the banker if one would label the trust as a living trust for the purposes of estate planning. Now, they may be thinking of the statutory definition of living, but we would be using it colloquially. This would be truthful because the principles of the trust are indeed living. The trust is not for disposing of the estate of a deceased person. So that was his first point. You have a comment on that?
Yes. Always remember that this is an irrevocable trust, and don't get it confused with living trust, which is basically a revocable trust that often married couples will set up so that if one passes on, then the property automatically goes to the second partner. That's called a revocable trust. But the problem with a revocable trust is that there's no separation of asset. In other words, the couple or the person still owns the property. If you are the settlor and the trustee and the beneficiary, then you have not separated that asset out of your pocket, and it's liable for any action. So the irrevocable trust is set up so that the settlor, either the trustee puts the asset, the settlor or the trustee puts the asset into the trust for the potential use of the beneficiary, either present time or down the road. But he doesn't own that property anymore, that asset. It belongs to the trust. And that's when the trustee has to be careful and not commingle any funds. So I always tell anybody, a trustee, if you're going to be a trustee, you pay yourself for incidentals. You don't go to the five and dime store and buy incidentals for yourself with a trust business. You just go to the bank, pay yourself, and then buy your incidentals for you. Now, I'm just saying personal incidentals, and that doesn't carry on to the rest, anything that has direct correspondence or direct adherence to the trust and the trust assets.
Yeah, and Randall, that was my thought as well, is that for benefit of everybody, when you go open a bank account and deal with banks with these trusts, you don't want to use words like common law. You don't want to use words like natural law or pure.
No.
They don't understand that. They feel that it doesn't fit with what they're used to. But for the benefit of Pat and everyone else, you can use the word irrevocable because that's the truth. And also, it's a word that they understand. It's a word that crosses over from both statutory and non-statutory types of trusts.
Sure. Irrevocable means you can't take it back. So when you set the trust up and you put these particular assets in, don't plan on pulling it back out later. It only goes to the beneficiary. Now, it doesn't mean you can't be the beneficiary and receive some of those dividends, but right in the first paragraph of the trust document says this is an irrevocable trust. And that's the first thing the banker would see or anybody would see, that this is a private irrevocable trust.
Yeah. So that was Pat's first comment. His second comment or question is, why do you limit the trust membership in an LLC to 98%? What is the weakness of a sole member LLC?
Well, I did that for a while, and then one of my bankers said for me to think about you want to see a person sometimes on an LLC. So I just chose a number. You can choose any number you want, but I said, well, I'll put my name down for 2% of the LLC and the trust would own 98%. But that ratio can vary anywhere you want. It can be 50-50 or however you want it. And maybe some people just want the trust to own the whole thing 100%, which is okay with me. It can be done.
Would it raise eyebrows?
No, I don't. Not necessarily. Again, it depends on the bank, the banker, on what you're doing with it. But I don't think it would necessarily weigh one way or the other.
All right.
It's a personal choice. That's what I'm saying.
Okay, so it's not likely to invite tax consequences or something, or audits or inquiries.
Well, not necessarily. That's the reason I stopped using an LLC, is because LLC is required to file, and how that filing happens is you have to make out a return, etc. Now, the LLC basically dumps all of its profit and writes off all the expenses. And then what's left goes to the trust and or you, if you happen to put a percentage in there. And I've never had a problem with it, but I stopped using the LLC because I didn't want to file a return. I was paying 2 tax returns when I was, filing the LLC, and I didn't want to do that.
Well, Randall, that raises a very good point. Is everybody, why use an LLC if you don't really have to? You can operate a business directly from the trust. I myself have done that. You've done it, Randall.
Yeah.
And it stays private. Everything is private about it. So, yeah, I mean, an LLC or any other statutory entity involves those yearly confessions,
Yep. You can, it's not critical. It's really, again, it's coming down to a personal choice. I mean, I compare it sometimes with having a storefront. The LLC is a storefront and the back office is your trust. But you can do the front office and the back office just with a trust. Not a problem.
If a person has already done business with an LLC for years and years and they've accumulated a lot of complex operations with it and it's comfortable, then fine, But
sure.
Otherwise, why bother with it? Yeah.
No, you don't necessarily want to take the if you've had a business for 20 years, you don't want to take it out of the LLC and transfer it. There's too much involved. In fact, I had a client and she said in order to disband the LLC and just put it all into the trust, it was going to cost her like $200 or $300. This was in Arizona, I guess. So it gets a little complicated. So I said, well, just leave the business in the LLC and operate that way and have the trust be 98 or 95 or whatever percentage you want it to own the LLC. Then the business continues on effortlessly and seamlessly, basically, and the reputation of that LLC stays intact.
There you go. All right. Now, Pat's last question is, assuming the trust's LLC can borrow funds from its manager's credit cards via minute order, will the repayment of that loan via direct payment to the manager's credit card constitute commingling of funds if the minute order stipulates that form of payment?
Yes, you could do that. In fact, in the beginning, you're probably going to have to use your credit in order to purchase things for the trust. Then, as long as you stipulate that you're using this card to buy this asset for this trust, and it's documented, then you can have the trust pay your credit card, pay for your credit card bill. And then what you want to do is work towards getting a credit card or at least a debit card for the trust. That's what I use now. Is I just have a debit card and a checking account under the name of the trust, and I use that to take care of anything that has to do with trust business.
There you go. And then we have some chat questions. Truby says, my question is, if the trust buys a house for all cash, is it permissible for the trustee to personally place a lien on the property by recording a UCC-1 showing full interest in the property?
Well, then it wouldn't belong to the trust. Yeah, you could probably do that. In fact, I've worked with a company that does just that. You set up your trust, and then they place a lien, UCC lien, on the trust for an extraordinary sum. So the first thing that has to be paid off is that lien, and they can't attack the trust. So yes, it can work like that. Especially if you know how to create a UCC document, which is what we did for the One People's Public Trust.
For the benefit of those who didn't know, that stands for Uniform Commercial Code, and our office is in the Secretary of State of most states and most countries, or all countries as far as I know.
Yeah, and you can just file it we filed all of ours in Washington, D.C. So wherever you are, there's always a place to file those records. I think it costs us $5 per UCC that we filed.
Right.
We had we were doing a lot of work in those days.
Mm-hmm. Okay. Thank you, Truby. Next, we have Aisha, who asks, good evening. Can a default judgment be deposited into a trust?
Who is in default? Trust or the person?
I'm assuming that she means the judgment is in favor of her or an individual, and therefore that individual has an asset. And that asset, I guess the question is, can that asset be deposited into the trust?
I think so, yes.
You would basically just do an exchange of title of ownership of that asset, right?
That's correct. And then you'd have to record it.
Because it's a public thing?
Well, no, because if let's say it's a piece of property. If it's a default judgment and it's money, then that can be placed in the account. It just has to be written in the minutes. If it's a piece of property, then it would have to be recorded with the county. But a default judgment that was mostly cash would automatically could go to the person's pocket, or it could go into the trust. I would think that if that's going to be a significant asset, that you'd want to have that default judgment or notice go in as an asset for the trust. And then it be protected and away from your pocket.
All right. Cliff asks, if you own a house and it is in the trust without an LLC, wouldn't that be a liability in the trust?
No, as long as the trust has proper insurance and maintains the condition of the property, it wouldn't be necessary. It's always a liability, potentially a liability, but if you take care of the property, it's basically a stable asset for the trust.
Right.
Mostly, it's anything that moves is where your liability comes.
Well, there are hundreds of tangents that you could take everyone on. So while we're waiting for the next question to come in, why don't you think of any of the other things that people have asked that typically, and let me ask you this, what are your concerns with the serving of your clients? I know you may always have things to say about that.
Oh, well, let's see. This morning I dealt with almost 12 clients and either was writing a trust for them or answering their questions. Some of them are really simple things that something was missing here or they didn't quite understand. And that's why these talks are so important, is because by listening either to live or to the recording of it, is you get little tidbits that allow you to work the asset of the trust versus not knowing or blundering into something that's going to get you into some trouble. So some are fairly intense and some of them are, it's like sometimes I need little things from people. I need to write back to them and say, well, I'm missing this, or I need you to think about this. Or they'll write me and they'll write me a long email sometimes with one question in it right at the very end. So I have to wade through that. But it's, I don't know, it's an enjoyable relationship for me to be talking with most of the clients. There's always some stumbling blocks, but people take my word. They, really question me. And if they have a question, then I give them a response. I, truthfully as I can, give them what they need.
Do you think, I know you've already said a lot in the past about choosing a trustee, but it continues to be an issue for some people who can't find a trustee. Do you have any comments on that?
Well, hopefully we're going to make this MMS group, professional trustee service, so that we can step in. And if you like, I had one client this morning, he said, I'm waiting for two really excellent trustees to show up. So I'm waiting for us to put our plan of action together and start having that service available to people.
Well, everyone, that's relating to our associate Mark Emery, who is the founder of Lighthouse Law Club and Monaco Management Group. And he is in cooperation with Randall and myself, with Brilliance and Commerce and House of Freedom, to create a subgroup or sub-service under Monaco Management Group called Monaco Management Services. So that's the MMS that Randall is referring to. And it, as a trust itself, will serve as trustee. So there is an example of where a trust can be a trustee. And Randall and Mark and I and maybe one or two others will be trustees of it. And there will be banking in Europe, in America, maybe in Panama, a few other places around the world as this spreads. Randall, any other comments on that?
Yeah, I think it's going to be an excellent service. I've had a couple of people today ask me, when are we going to get this going? And I keep saying it's in process and just hang in there. In the meantime, you can have your own trustees ready to go. Don't delay that. You can always shift trustee service later. But we're working on making the MMS functioning sooner than later.
do you have a comment on what criteria people should use in deciding whether they themselves should be trustee?
Most of the people that want to be trustees want to be in control. And that's always an issue for certain people. Some people just want to turn it over to a trustee service and relax in the asset base and just be one of the beneficiaries. And some people like to be really active, so they want to be at least one trustee. So I try to encourage people to have, if not two trustees, two co-trustees, that they have themselves as a trustee, and then you must have a successor trustee ready to go in case something happens to you. You can't leave the trust without a trustee, because the government will come in and assets will be, the government will appoint a trustee, their own trustee.
Okay. Jules writes, what is your business contact information? And Jules, maybe you missed the beginning of the webinar. We'll just mention it briefly and then we'll go on to the rest of the questions. And that is, get back to the person who introduced you or an affiliate who may have given you the contact with us. If you don't have one, if somehow you discovered us by some sort of search, then just go to house-of-freedom-trust.com. So House of Freedom Trust with dashes between each of the words.com, and you should find all the contact info there and all the information. We have a telephone questioner here, so I'm going to unmute JB. If you would like to ask your question, you are unmuted and you're on the air now.
Oh, hi. Hi, both of you.
Hi,
two questions. Hi. Two questions. One is, can you use a calendar to constitute minutes? That's one.
Sure.
And I understood that you can change beneficiaries with a minute order at any time. Is that not true? I mean, once you have a beneficiary, I mean, you could have an institution or a corporation that you no longer, I mean, it caved and it's no longer
Right.
Viable, or you have a child that passed away, or you don't want to give it to certain beneficiaries. So how does that work? And so those are my two questions.
Well, one is you can change the beneficiary whenever you want. You can change the percentages. It's just a minute that you would introduce into the trust log. Just be like if somebody passes away or the institution you don't want to support anymore, then you would just write a minute and say, we're going to take it somewhere else. And the percentages can change. I worked with a client this morning, and we changed over a period of time, last couple of days, we've basically changed the percentage on the beneficiaries.
Okay, and the calendar, can that constitute minutes?
If you can be more detailed, that's better. But yes, I mean, if you have, if you take some activity and you write it down and you sign it, and the only issue I have with that is then if there's another co-trustee, how are you going to get them? You'd have to make a copy and send them a copy of your comment, and then they would have to send it back. So better to have drawn out minutes rather than, unless you have a big calendar, have one of those big wall calendars,
yeah,
with lots of space in it. So yeah, you could do that way.
But I mean, does the trustee, the co-trustee, have to have their autograph the same day that you entered your minute, or can it be they saw it and it's okay with them a week later and they note it in the calendar?
Yeah, you just say you make a minute and you take some activity, and the other trustee is traveling, not available, but you know how to send an attachment. So that's what you do. You would make a copy and email that attachment to your co-trustee, and then they would get it back to you, and you slide it into the minutes.
Okay, and you mentioned something about the government. Well, the last thing we want with any trust is the government interceding.
Right.
Yeah.
That's
How?
Well,
You,
go ahead. Sorry.
no, but I mean, even if you don't have you're the sole trustee, you don't have a co-trustee or a successor. I mean, I know it's very valuable to have a successor trustee. You must have a successor. One of the important things in a will, I mean, if you don't have a successor trustee. But if the government gets, I mean, that's pretty serious. That's almost like you're talking about divvying up an estate again. You're talking about reverting back to
court.
What you wanted to avoid in the beginning. Reason why you wanted to have a trust was to avoid probate.
Yes, that's
it sounds like you're going back to probate.
That's why you want to have either a co-trustee or a successor trustee.
But like you might not have appointed one yet. You're in the process of learning and it's growing, and then you die or something happens.
Well, then you'd want to have a successor trustee before you start to grow those assets. That's all I'm saying. Better to get one now, because the court, if you have certain assets in the trust and you're the only trustee, there's nobody else around, then the court will step in and say, well, we have to appoint a court trustee. That's why you want to have a successor trustee or a co-trustee ready to go.
Can you have a will to back you up in case you don't have an assigned successor?
What's the will going to say? I mean,
in the event of my death, I've got cousin or somebody else in the family who didn't want to be a trustee.
I've never heard of a will stepping in as a trustee. It just doesn't make sense. So what I'm suggesting is that you have a co-trustee or a successor trustee or a trustee service.
Right. Okay. All right. Thanks.
Okay, JB?
Yeah, thank you.
Okay, well, thank you. Yeah, thank you very much. Okay, moving on. We have questions in the chat. This is, I guess, just says attendee. Can I be the trustee and one of the beneficiaries? Or if I want to be the trustee, should I make only my children the beneficiaries? Or if I want to be a beneficiary, I have to find a trustee?
You can be a trustee and a beneficiary. You can't be the sole trustee and the sole beneficiary. So you'd have to have one or two or more beneficiaries. And like I'm talking about earlier, it's better to have a second trustee, a co-trustee, or a successor trustee. But you just can't think about having a trust and you being the only trustee and you being the only beneficiary. Now, if you want to leave the assets to your children, then all you need is a successor trustee to look over those assets for your children.
There you go. Okay. Aisha asks one more question. If a defendant is subpoenaed but does not appear and the judge refused to sign a default judgment, what is needed from the court to deposit into the trust?
Who's the defendant? Is it the trust that's a defendant or some person?
So Aisha, you may want to answer that in your chat, but
yeah, I'd have to explore that a little bit, but if the default, if the default's against a person, then it wouldn't have anything to do with the trust assets because the trust owns those assets, not the person that's in default.
Seems like common sense that the judge would have to sign the judgment in order for it to become an asset. And until it's an asset, there's nothing to transfer to the trust.
No.
Okay. She writes, no, the trust is not set up yet. We are talking about the default as assets to deposit.
Yes, it's possible, but then if you already have the default, then it's ready to go into a trust.
Yeah, it has to be court authorized, obviously.
Yeah.
To become an asset. Well, let's ask this theoretically. Let's say it's in the process of being litigated and it hasn't yet become an asset. Could the potential future value of it go ahead and be transferred into the trust? The title of ownership of it?
What if the default doesn't go your way? Then you're done something for nothing. So I would get the default judgment first and then take that asset and put it in the trust.
Yes. And for everyone who wants to know how to do that, that's what you have Randall for. As a client, if you're a trust client, Randall assists in how to make the transfer or exchange of the title of ownership of any asset.
Right.
And how that process is done.
With great assistance from Tansen.
No, it's mainly your work, but thank you. Mata asks, if choosing to use professional trustee, how much authority or activity would a manager have? For example, will the manager manage or sign on a bank account to handle daily activities? Really? The trustees can change the beneficiaries? How does that preserve the settler's wishes? So I got kind of looks like two different questions here.
Questions, yeah. Say the first question first again.
For example, will the manager manage or sign on a bank account to handle daily activities if the client has a professional trustee?
Depends on the bank. Always in the early days, the banks didn't have a problem with the general manager going in and signing the bank account and being on the check or the debit card. And somehow the banks got really tight. And now most banks, unless you happen to have a personal relationship with the banker, they want the trustees only on the signing of the bank card. Just depends on the bank.
Which means if the bank doesn't allow it, then say thank you and walk down the street and go to a different bank, huh?
Other one, or just basically you got to trust your trustee. Also, I mean, you still have the daily activity to contend with, and you may, depending on the bank, you may not have the right to sign on checks, but you can easily make or have the trustee, let's say, sign a few checks in advance, and you would have to be accountable for those checks, but you could carry them with you, or you could pay certain bills, or you would just have the trustee do that. I mean, now everything is so online anyway that you have all your accounts online. You have almost constant contact with your trustees, and all you have to do is say, I need you to go online, and I want you to, buy this asset for the trust, or et cetera, or sell this asset from the trust to somebody else. So it's easily manageable. It just depends on the bank, again.
And Mata's second question is a good one for the benefit of everybody. The trustees can change the beneficiaries. How does that preserve the settler's wishes?
Well, they're not just going to go change the trustees willy-nilly. But let's say that settler...
Change the beneficiaries.
Yeah, say you're going to have a number of beneficiaries, and then the settler at some point has to say, in the event of my passing or whatever, I want the trustees to choose the next level of beneficiaries, or here's a list of beneficiaries in an order of progression. So let's say you have 4 beneficiaries now, and you have 4 more potential beneficiaries that you want to have flow of the assets to. Then you would make that list, and the trustees would take that wish, and that would progress from there.
Mm-hmm.
And, what happens is, let's say you create the trust and you're either the trustee or the manager, and you have 4 children. Well, let's say those 4 children all get married and they have children. So now you got grandchildren, and it progresses out. And that's why when the Rockefellers and the Kennedys finished, there were hundreds of trusts, because every time a child was born or a new entity was happening in the family, then they would be added to that list, or a new trust would be created.
Okay. This question is, can I put my retirement pension, such as an IRA, into the trust without triggering a taxable event?
I don't think so. I've been having to contend with that issue before, and I said you got to check with your IRA and see how they felt about that, because it just depends on how it was set up, and it may not be transferable into the trust, but it also may. Depends on what kind of IRA you've got set up, and
if it's self-directed.
if it's self-directed, then yes, you can do that. If it's with a group, then you probably can't.
But it would be taxable to the individual owner probably before
Yes.
It gets to the trust.
Yeah. I mean, if you want to take the hit on the taxes, then you do that, and then you can put that asset into the trust free and clear, and then build it again.
Yeah, and then from then it's tax-free.
Yeah, but then I would have you consider, if this is your personal IRA and you've been working a long time and it's built up to a pretty good space, that you leave that alone, because I think that they're fairly protected anyway. In other words, your IRA is pretty judgment free, depending on what kind of liability you create.
Mm-hmm.
I'm not sure about that. I'd have to check.
Okay. This question is from Hans. Does the successor trustee have to be kept informed with minutes like a normal trustee?
No, but it's always, because they may not have anything to do with the trust for 10 years. So I would just have a second set of records that's available to go to that successor trustee if needed.
And he says, is he part of the trustee team for all meetings, etc.?
No, he wouldn't really have anything to do with the trust until you've stepped aside.
So you might just get a copy of the basic indenture and not be kept up to date necessarily on everything until close to the time of,
Right.
yeah.
Right.
And or does he only become active after he takes over the responsibilities?
Pretty much. That's when he steps up to take that. Now, it's always prudent probably for the first trustee to keep that successor trustee informed. Depends on your personal relationship with that successor trustee, but typically if you're going to have somebody be a successor trustee, it's somebody you want to step in if you step aside.
Okay. Aisha asks, please give contact information. Aisha, we mentioned that earlier, but basically it's houseoffreedomtrust.com, and then you just click on contact us. Yep. House of Freedom with dashes between each of the words, house-of-freedom-trust.com, and click on contact us. That's how you get in touch with us. JB has another question. So, JB, would you like to go ahead?
Yeah, this is a mathematical one, and it's rather elementary. So let's say you have, I don't know, $75. You've created 3 trusts, okay? Or whatever. You have 3 trusts. And you have $75. This isn't just random. Do you put 75? That's your asset. You put 75 in each of those 3, or do you put 25 in each of those 3?
How can you put 75 in each one if you only have $75? You'd have to put 25.
Well, I'm trying to figure out, is it they're separate trusts.
Yes.
So how do you divvy up the math? What
Any way you want.
Okay, so in a currency,
You only have a total of $75. So you've got to break that into three parts, whatever ratio you want.
okay, so now I want to expand that to assets for, let's say, currencies. If would it be best to like put one trust for humanitarian funds exclusively, and where the beneficiaries are different? It gets a little complicated, and the other one is a little bit more, the currencies are a little bit more self-directed for personal use. So how would you divvy up? I mean, you're creating separate trusts, or are you creating sub-accounts for these exchanges? I mean, these currencies. How does one best construct or organize such, because the humanitarian project or the humanitarian currencies are going to be separate from the other ones, which are not going to be directed towards humanitarian efforts. So how would you, Randall, segregate them, for instance? How would you design?
I'm not.
How would you keep them separate? Because
I wouldn't. I'd put all of currency into one trust and then wait for the exchange. So when the exchange happens, then you can break it up on that new asset base. And that, the way you do that is up to you. Any percentage that you want, you can dictate to each trust.
Okay, but certain assets, ones geared towards humanitarian projects will be heavily monitored. So it's probably better to separate that one into its own trust for monitoring purposes. I'm trying to figure how to, and then the beneficiaries might be different in each of these. So you don't do sub-accounts under one trust. You would best be handled if you create separate trusts for these currencies, or can you do just sub-accounts under one trust?
It's a choice that you can make on your own. I mean, I'm saying that I'm doing it one way, but you may decide that you want to have a humanitarian trust before you do the exchange. So you take so much currency and you put it into trust number 1, and you take trust 2 and 3 and you put in a certain amount of that currency. That's totally up to you. Or you can just put it in one trust, and then when the currency happens, then you can break that out into multiple places at that point. It's just a choice you have to decide on.
Well, my experience in trust operations is 0, with 0 years, whereas yours, you've used your trust and operated trust for 25 years. So you have more of a familiarity with how these things work. So it's up to you is kind of, yeah, sure. But if you know what you're doing, it's up to you. If you don't know what you're doing, there's a little bit more involved. So
when it happens,
commingle.
when it happens, then you can call me or email me and say, "Hey, I have this dilemma. What's your suggestion?" And I'm just going to suggest, like I'm suggesting now, as it's a choice that you will make at some point along the way. You'll either break up that $75 now, or you'll put it all in one trust and then break it up after the exchange happens, if that's what you want. It's your experience will happen as you go along with this. It's not
So
that
you
complex. It's
suggesting
really you make it, you overthink it, and you make it more complex than it really is. It's just a decision that you make on a percentage you want to go into one trust, and you want percentage to go into the other two, or you can put it all in one and let it sit there and wait for. I wouldn't put it all in one. I'd like put in think about the percentage you want to go for the projects. Let's say they're suggesting 80% for humanitarian projects and 20% for personal stuff. Okay, so you take 80% and you put it into one trust for humanitarian purposes, and then you take 10% in those each other two, and that's yours to use, and the trust can use it as it wants.
Okay. And are you on the up on the IRS issues? Because my understanding is there isn't any. There isn't going to be one. But
I don't even want to talk about that in this conversation. That's a fly by night. We don't know what's
no,
happening.
but I mean, are these trusts, these irrevocable trusts, taxable trusts? I mean, I'm hoping they're not.
Not. Nothing's taxable.
Okay. Good. That's the way I see it. So I just didn't know if some things were
No.
taxable events and others weren't.
JB,
Okay,
have you
thank
read
you.
the ebook?
The trust manual, you mean?
No, not the manual. The ebook. It was 50 pages. Now it's up to 60 pages. It's
No, I have
downloadable
not.
off the website, because that would answer a lot
Oh,
of these questions that you're asking. And I recommend everybody, if you haven't read it, please read the ebook.
okay. Thank you. Thank
You're
you.
most welcome.
Yeah.
And those were good questions, by the way. They're beneficial for everyone. Okay, moving on. We have 828 area code, and let's unmute you and ask you to ask your question, please.
Hi, Randall. This is Lynn Gregory with yet more questions.
Oh, Lynn, didn't I talk to you this morning 4 or 5 times?
Oh, yeah. Well, I can relate to other callers saying they have zero experience, but I've got a couple questions here. I did read the manual, and when I go to set up a bank account, am I going to be looking to set up a non-interest bearing small business account?
If they have it.
If they have it. But the main thing is that it needs to be non-interest bearing. Is that correct?
Yeah, it doesn't matter. It depends on the bank, and it's not a critical matter at this point.
Okay.
Because for one thing, if you're involved in this currency, and it does happen, the banking system's going to change radically. So that's why I don't want to go too much into the future, but you can easily make choices that will help you resolve all of those issues.
Okay. And in terms of the woman that you were just speaking to, it made me wonder, can I have more than one bank account in my trust? Like have one bank account primarily for my beneficiaries,
Sure.
for disbursements, and then maybe set aside another in a bank account for humanitarian projects?
Yep.
Okay, I think that's how I would separate the funds.
Any way you want.
Oh, right. Okay, that you've answered it very succinctly. Thank you so much.
Sure.
Randall, I think that what a lot of people are encountering, and you probably have noticed this too, is that they expect trust information to be so complicated, right? You know, they expect the the whole topic
Yes.
to be beyond their comprehension and only understood by attorneys and accountants. And it's so different with a common law or a natural law trust.
Just keep it simple.
Mm-hmm. And it doesn't make it any weaker. As a matter of fact, it makes it stronger.
Sure. It's not all the complexity that you have with a 250-page trust document. I mean, you can do that if you want, and you can explain all the details, but who's going to read it?
Right.
The trust document we have ranges from anywhere from 35 pages to maybe 45 pages, depending on a number of things. But the trust indenture itself is only 15 pages. And then you have about 10 pages for appointments and acceptances, and then you have the minutes. But there's not a whole lot more than that. And the more simple you keep it, and the more you make choices based on your experience in life, then the easier it gets. You can, like we talked to Jan and Lynn, it's like just decide what kind of percentage you want to put into one trust or all of them or sub-accounts. And it's just a choice that you make when you this all happens.
And some of the simplest things are some of the most powerful things in the world.
Yes, absolutely.
And not only the simplicity, but the freedom that people maybe are not so used to. Everybody's so used to being regulated, and you've got thousands of rules to follow, and you've got to comply with these regulations and laws and rules and so forth. And then they come across this, and they're like, well, what are the rules? And there are some, right? There are some basic ones, but
sure.
You keep, I think, surprising people by saying it's up to you. You can do what you want, and they're not used to hearing that. You know?
Well, yeah, they're not used to it, obviously. Help me.
That's why it's called House of Freedom. Yeah, we use the phrase infinitely flexible.
Yes. Yoga.
Mata, go ahead.
Yoga master.
Yeah. Mata asks, if I have two trustees, do banks require both trustees to be signers on the bank account? And do both need to sign each check?
No, you may both have to sign on the bank card, but only one of you needs to be on the checkbook, and either one can keep the checkbook in your pocket. Again, it comes down to a choice. And it depends on the bank. They may want to have both trustee names on the checkbook. They may not care. But typically when I was on the mainland and I opened up my Wells Fargo, I was just the sole signature on the account.
Don't you include 3 words in the banking resolution, one signature required?
Yes, only one signature required, and it can be either or. In other words, if you have 2 trustees, it's either or. If you have 1 trustee, then it'd be 1, but it just depends on how you've set up that banking resolution minute.
Usually you would want 2 signatures if it's large transactions, right?
Well, not necessarily needed, but if you're doing any kind of larger activity or larger transaction, then you have to at least have the other trustees' approval before you do that. You may not need both signatures on the account. You may want them to be, let's say on a transaction larger than $250,000, you may say we need both trustees' signatures, or you may put it at 50, just depends.
But again, it's up to the creator of the trust to make that decision.
Yes, and the bank.
And the bank. Well, hopefully, Mata, that answered your question. And can we, Randall, it looks like JB has another one. Would you like to take another question?
Sure.
Okay. JB, you are unmuted again. And what was your question?
Have you considered between the two of you like a study group? Like I'd like to form with the people here, if we can have like a team approach where we don't bother Randall so much with all these questions and go over and review the trust together and just work I'm used to study groups and when I went to university. So is there anybody that's interested? Maybe they can, this way we can work it out. Different, maybe people who have been in this trust situation a little bit longer, and then there are others that are just starting out, and that we can review these documents together. We don't need to bother all these mundane questions all the time, but I have thousands of them. So and you eliminate a lot of this when it's operational. For instance, another little trick: you don't ever have your trustee name put on the debit card, or you want just the trust name, or your initials for a trustee, because you just don't want people to know that you're connected to that trust. So I know someone who had her trustee name removed immediately, and they complied. But there's a lot of little things one can do if we can just go over it together. So how would somebody who's interested in something like that contact whomever? Can they contact you, Randall, and set up these
put it out there
study groups?
Put it out there yourself, and just say you want to start a chat line or open mic or an open chat line. And, you're telling 60 or so people right now that you want to do that, and they can contact you. You've got to put out your information on how to get a hold of you, and then start it.
Would you recommend that they go through the Passing the Buck book?
Well, that's one of them for sure.
JB, the Passing the Buck is a book that's been recommended several times in our newsletters, and it's in the bibliography. Randall has recommended that as one of the good books that complies with the kind of House of Freedom Trust that we provide, and it teaches the principles of it.
Yeah. See, there you go. You got people take down your information, Shabby, then they can start to connect with you on your computer and start from there.
So everyone?
Yeah, I mean, I think it would be very valuable for people to just review these things and have these interpretive questions, study it together. And if there's a question that comes along, we have each other. We don't necessarily have to bother you. I think that would minimize your workload tremendously, Randall. So I think everybody would benefit. I don't see a risk there at all. I think everyone would benefit from that. And if we can't come to some sort of agreement on something, then we can ask you or something like that. I just think study groups are great because we all have ways of looking at that trust differently, and with different levels of experience, we could really learn how to move with it, in a faster way. So that's all. I just don't feel very secure with my trust. Pardon?
You just put it out there, so wait for somebody to show up.
If I may just comment
Sure.
about the debit card idea, if you were a billionaire and you were afraid that people might kill you to get a control of your billions, and you wanted to keep your name away from the trust contains the money, you could keep your name off of things, but you could also put that trust, as wealthy people do, under another trust, under another trust, under another trust. Randall is also able to help people with layering and what we call estate engineering, asset protection engineering, where you have multiple layers of trusts. So Trust ABC has no money in it, but it's the trust for Trust XYZ, and XYZ has the money.
Mm-hmm.
So when the public sees that you're trustee of ABC, they say, oh, he doesn't have anything.
Right.
So, and the fact that it's trustee of another trust is hidden from the public. So that's how that's done. On a practical level, for most people who are more middle class and have average assets, I will assure you that if you travel with a debit card that only has a business name on it, you're going to have trouble getting airline reservations, hotel reservations. You're going to have trouble when you travel and things like that because your personal name's not on it, and they don't book a room to a business. They book a room to a person. So I have found that there's been absolutely zero problem in having my name as the user of that card, even though I'm not the owner of the account. I'm the user because I'm connected to the trust. The trust owns the account, but my name is on it as a user, and
Right.
that's fine.
Yeah, that's how it typically has to work. It's very rare that you can get the name of the trust on any card. I think every one of the cards that I have has my name on it, and they won't put the name of the trust on it because you can't do anything with it if it's not your card. That's a good point, Tanzan.
Well, actually, they do. They put both on mine. They put
Yeah.
my personal name and the trust name.
Well, as long as you have both, then you're all right.
Yeah. 605 area code. You have been with your hand up here, so let's unmute you and ask you if you would like to state your question. 605.
Yes, I'm Suzanne from South Dakota. I'm just starting all of this.
Hi, Suzanne.
Hi. I've listened to a couple of calls, but I've got a lot more to look at. But I thought, being I'm on the call, the very beginning, when I started thinking about having a trust, the word foundation came up, and what little I've read on that, can't donate to it or different things. I'm legal as a church in South Dakota only at the moment, and an ordained minister, so I didn't know if I could do a foundation with a church doing it. Well, anyway, have a DBA, some way that it could be donated to is what I was trying to work on.
Well, if you're the minister, if you're the ordained minister, then you could create a trust and, support that ministry with your donations.
And the trust can operate as a foundation.
Yeah.
Oh, good. Because that's what I heard. I heard that name came up, and I thought, well, okay, I kind of was told to do that. Okay, well, that kind of answers that. Got a lot of reading to do. I'll keep going.
Okay,
definitely.
That's good.
Okay, well, thank you.
Thank you very much.
Okay.
Further comments?
Do we wrap this up?
Yeah, we sure can. Let's go on into our concluding session phase, and then we can see if we can see whether anybody comes up with anything to conclude with. But for now, we'll go ahead, everyone, with the last part of this meeting, and we will review the fact that those who have asked several times how to get in touch, we ask you to get in touch with the affiliate who introduced you and use their link for clicking on our website. If you don't have that, if you somehow found us by landing from a spaceship, then use houseoffreedomtrust.com with dashes between each of the words. Contact us is on the website. We have someone, Lori, asking, have you heard anything on the status of RV funds? I realize this is not the topic, but just curious. What do you have to say about that, Randall?
I don't know.
Well, we do, in honor of your question, Lori, and for those who are not familiar with what she's referring to the revaluation of currencies, and those who have invested in certain of the undervalued currencies are expecting to have a huge gain. And the ownership of that is ideally placed in one of these trusts. So it comes up a lot in our community because a global currency reset and a global consciousness reset is underway. So I know Randall and I recognize the inevitability of such changes, and yet at the same time, we would be foolish to try to give a date. Everybody in the past who's given a date has been proven wrong thus far. On the screen here, we see October 10th today, 2018, and November 7th, our next and possibly last for the year webinar. Now, Randall, what do you think as far as December? You think we should take a break and wait until January?
I would, around that first week, and even I don't know the dates offhand, but I would say maybe around the middle of January, start up again. Everybody's been through the holidays. We may have some action actually on the RV, we don't know, but we'll have more activity in the level of trust work. And I think we'll just, I think what I'll do for November is do a summation of our, year's worth of work, and just recap the whole process. Maybe recap the trust, recap we should by next month know about MMG and MMS group and wealth management. So we may have more information on that as well.
All right, so everyone put November 7th on your calendar, and we'll probably take a break in December. So November 7th would be the last webinar for the year. Matt, you've got your hand raised. Let me unmute you and see what you have to say. Matt? You are unmuted, Matt. Okay. Going once, going twice. Okay. All right. Well, everyone, thank you for joining us. We've really enjoyed, I would have to say, Randall, this has been, again, a wonderful audience with great questions, great concerns. And there are so many very, very good humanitarian projects coming forward. So many very good people with good wishes for the betterment of mankind.
Yeah, I think we've both done a good job, and the quality of questions keeps on getting better. People understand a little bit more. Beginning people get a little more clarity a little more quickly, and I was just looking at the calendar, and I think January 9th would be the Wednesday, second Wednesday in January. So we're going to do Wednesdays?
Yes.
All right. So that would probably be the 9th. I don't want to do it on the 2nd. So we'll think about the 9th, January 9th, and we'll have one next month on the 7th. Yes?
Yes. JB asked, please review where we can get the back recordings. So the playbacks of these webinars, everyone, are posted in our newsletters. Here on the screen are the newsletter details and the phone number and the website, houseoffreedomtrust.com, with dashes between the words. So you'll see on there, subscribe to newsletter if you're not already subscribed. We announce the dates, and also we give the links to the YouTube link, playbacks of these webinars. Okay. So,
very good.
Yeah, mahalo, as they say in Hawaii. Thank you.
Yes, you're most welcome.
All right, everyone. Take care. Blessings, and have a wonderful October.
Thank you, everybody.